Do I want to live under man or do I want to live under God? And it really is that kind of simple. Under man, he has how many codes, rules, statutes, etc.?
60 million.
Tens and tens of millions of rules, codes, and statutes. And more passed every year. So it's real easy for me to know that I don't want to live under man, nor can I. Because I can't win in his courts. Or its courts. Or this world. I'll be of the world, but not of this world. So, I know that I don't want to be under man because I can't do it. Can't live with those codes, rules, and statutes. Today we have going on in America, and probably Canada the same, is you have a choice. All your life's going to be made up of choices. The republic or the democracy. And we talked about certain things such as and these are words that are going to reoccur all the time. Democracy and republic. In the republic, in America, 307 million wolves can't eat this one sheep. In a democracy, it seems a plurality does it, and that's all it takes. Because whoever's counting the votes, not what the vote really means. But why would you subject yourself to voting anyway? Are we all going to, is this much of the room going to agree that this is the rules we're going to do? We're going to pay these taxes, this, that, and the other thing? It's difficult for most people in America to understand that income taxes for the average individual, what didn't even exist prior to the 40s. Walt Disney was enlisted by the U.S. government to assist and encourage people with Donald Duck to voluntarily pay the victory tax. Are these guys rev scammers or con men or fraudsters? Are they?
I'm thinking, yeah.
Well, that's to presuppose there's no real game in life, or that life's not a game. And I contend it's a game. You can be under God or you can be under man. And for me, it's really important to understand man's position in the game. Is it okay to lie, cheat, and steal and do those things? I contend it absolutely is. Is it okay for Social Security not to pay you but a pittance on what you purportedly put in? Absolutely. It's correct and right. What should you be allowed to do with your property?
Whatever you want.
Whatever you want. And some corporation should be allowed to do with its property whatever it wants. Should it not?
Sure.
Now, under God's rules, you have the Bible, and I like the King James Version, because in it is all the rules for playing the game. Proverbs. Proverbs 11:15. He that is surety for a stranger shall smart for it, and he that hateth suretyship is sure. Have you heard that to define a problem is to half solve it? If you give that little maxim some thought, you'll realize that such is the case. To define a problem is to half solve it. So what's the problem? We've all heard that we're the enemy. We give a lot of lip service to that, but are you really your own worst enemy? Do you think? Why? I like the why, because if you can't get to the why instead of all of this somebody says something, what's the point? I need to know the why. Why am I my own worst enemy?
Lack of knowledge.
Well, under God's deal, what's that got to do with anything? some of you heard my people perish for lack of knowledge? Oh, okay, so the Bible does kind of tell me these things. Of course, in this world, we're all smart. We got so much going, etc. What's a proverb? Webster's, I love the definition of it. An enigmatic saying in which a profound truth is cloaked. He that is surety for a stranger shall smart for it. Find the problem. What is the problem? Our problem, in my opinion, is we keep stepping into suretyship. We become responsible for Gordon Hall, Juanita Chung, Colin, Pat, Tom, whoever's stuff. Doesn't matter if it's uppercase, lowercase, or whatever. Let's not get hung on upper and lowercase and which court am I. There's only one court if they're dragging you in there. They're not dragging you in, they invited you. So everything that you're going to do should have some basis in the Bible. Most people don't know that the Bible was a law book in law schools for a long, long time in America. The major book. Now also in the Bible, in Romans 12:2, it says, "Be not conformed to this world, but be ye" what? "Transformed by a renewing of your mind, that ye may prove what is right and acceptable and perfect will of God." That ye may prove that is good and perfect will of God and acceptable, etc. A renewing of your mind. No more arguing, no more fighting, etc. We've talked about the 4 doors to go through. Most of you, anybody unfamiliar with that concept? Acceptance, conditional acceptance, argue, and silence. You're in the commercial world. We're sailing the seas of commerce. Look up the word sea sometime. Look up the word commerce sometime. Sea just doesn't mean a body of water. It's rather interesting what it says. So, in the seas of commerce, you're going to have presentments all the time. You've got your straight acceptance. You just flat agree. You got your conditional acceptance, all right? And you got your silence. And you've got your arguing or fighting. Is there another door you could go through from any commercial presentment? Is there?
No, but
That's it. Every commercial presentment is going to be responded in these 4 ways and those 4 ways only. No matter what response comes, it's going to fall under one of those categories. You've been there, we've talked about it. Pretty clear. Really, this is going to be rather simple. These 2, you're in honor and you're a creditor. These 2, you're in dishonor and you're a debtor. Creditors never lose. What's a creditor?
someone who solves problems.
Nope. One to whom something is owed. Kind of interesting. See how they define that here real quick.
extends credit or to whom?
Creditor, person who extends credit to whom money is owed. Was money. You all and I think we know what money means, but this is a reason I'm going to suggest that you must obtain a Webster's College fourth or third. What I like about the fourth or third, you see the gray areas that are highlighted in this?
Yes, I do.
Those are synonyms. That means just words that are similar. Like this says, irritate, provoke, nettle, exasperate, peeve. And then it goes into, above it is irritate, and it defines it, but in here, irritate. The broadest in scope of these terms may suggest temporary, superficial impatience, blah, blah, blah. Provoke means is to arouse strong annoyance and resentment. It goes on to explain the little fine nuances of those words. So wherever I see words like creditor or debtor or any other word, more specifically, let's go to the word assert. Interestingly, that assert is in gray. You have assert and declare and affirm and aver and avouch. Dang. It's a whole lot of words that kind of mean the same thing. We use a lot of words that kind of mean the same thing, but in law is an entirely different language. And it's very precise and concise what words mean in law. Context defines the meaning of a word. Assert, if you go up into the definition of assert just in the white area, to state positively, declare, affirm, to maintain or defend, to insist on one's rights or being recognized. And when you go down into the synonyms, to state positively with great confidence, but with no objective proof. And that's what struck a bell with me is when I got into the synonym. Not the definition up above, but with no objective proof. Objective, an object. Subjective is of the mind. So, the definition or the maxim in law, he who fails to assert his rights has none, took on a whole different meaning for me when I saw that addition, but with no objective proof. How did that correlate with being in God, under God? Well, if I'm presenting my UCC1s and trying to do evidence, then I'm lacking faith in God. I'm not asserting my rights. He who fails to assert his rights. If I had just looked up assert and said state positively with great confidence or affirm or whatever, I couldn't have gotten what I understand it means for me. Can't be used in proof. And that led me then to go on to understand I don't need evidence in court in a certain sense. I don't go in there, or if I'm arrested or something, let them prove something. I know you can't prove anything, so we're going to talk about a few principles of the game so you can get it. Some of the principles. This is it for your choices with every commercial presentment. Policeman stops you, somebody wants to arrest you. More importantly, you get a summons to a court. And this is what we need to look at a little bit. A process server gives you an offer. And this is going to be real critical for the game. Process server Juanita gave you that from the court. So somebody went to that court, and let's step back a little bit. These are real critical on some questions that I really like. Do you have the 11 pages of Q&A? Some of you have gotten the 11 pages of Q&A. It's like page 8 or 9. And let's walk through this just a little bit. Is it not true there is both a public and a private trust that run parallel in today's society? Do you agree with that? Do you understand that? Do all of you understand what's meant by that? Okay, good. We have a private side and a public side. The public side being judges and policemen. The public. Now, in that series of questions, the second one, so would you agree with me that there's a public side to this world and a private side? Private side meaning individuals and interactions among individuals or corporations acting in the capacity of an individual.
Yes.
All right? That's the private side. The second question says, is it not true that the public has not the resources to resolve all problems in the private? Do you know what's meant by that? I use this example. Juanita bumps into my car. Oh my gosh, my neck, my sex drive, my life's ruined. I need $100 million. Colin says, God dang, Gordon's got a G5 jet. The new G6s are out. I need a G5 too, and I need a bigger mansion than he's got, or I need this, I need that. The public can't resolve everybody's problems, can they? They don't have the resources. Does that make sense? So, there's a public side and a private side, and the public can't fix everybody's problem. They don't have the resources. The third one, is it not true that essentially the only reason that we have public trustees involved in fixing problems is because the private parties fail to resolve it? Think about that. When does the police get called into a matter? You're having an argument with your friend, or a fight, or something goes off, or you're suing this guy, or he won't give you your lawnmower back, or he won't quit doing this, or his kid is running over your grass with his go-kart and tearing it up, or doing Brody's in it, or he continually leaves his bicycle in your driveway, and you finally get pissed and run the thing over. Right? And the police get called in. Why were the police called in? Because the private parties couldn't resolve it. Make sense? And I kind of like the fifth one rather than jump into the fourth one. Are you suggesting that the record I provided to you, which has resolved the problem in private, still grants jurisdiction in the public to continue a matter already settled? So if we think that the only reason we have public officials, courts, is when the private parties have not resolved it, then if the private parties have resolved it, do we need to go to the public? Absolutely not. And this is where the crux of your win comes in. I'm working with a guy that's up on a murder trial, up on a murder charge, second-degree murder charge over there in Arizona for shooting a guy at his car window. Guy came to his car window, we got a road rage fighting, and he's dead, okay? It doesn't matter how, why he's dead. We got a gun discharge that came out of the car. We got somebody charged. We got 2 doctors up in Cincinnati, Ohio that are charged, given a commercial presentment, and charged with something with IRS, income tax evasion, filing false instruments, whatever. It doesn't matter what the charge is. Now we're going forward, especially let's look at the murder guy for a moment and apply this concept of those we'll call them 5 questions, but I kind of like the 4 a little bit. Let's say that this guy John Stewart, which is a real guy, his name is really John Stewart, and he really was involved in shooting somebody at an intersection and blew him away. His charge is a drive-by shooting and all sorts of other things that have to do with the case. He spent almost $600,000 with attorneys. They bled him out of all his money. His wife left him, took whatever money they had and some more money, and blew him off. And she just walked out. They didn't have a formal marriage, so like any good debtor, she just, we're married, we're living together, we got a contract, but it's the end. I'm out. You can terminate a contract anytime you want as a sovereign. Kind of interesting that we have legal marriages that don't allow people to get out of them so easy. Is that good? I think it is. How many people just get fed up with each other and want to mess with the kids? They just walk out and leave the responsibilities. So see, the government's there to help a lot of these people try and resolve and come together, because you see, they gave their word when they entered into that deal, didn't they? As soon as they had children, who is their duty to? To the kids. They don't have rights anymore. They only have duties and obligations once you've had children. Not condemning anybody that does or doesn't do it. Just the fact is, whose responsibility is that child? Is it yours? You had a certain responsibility to, you made an agreement when you entered into it to honor, to love, sickness and health, good and bad, right? And a lot of people, we have 50% of America getting divorces. Breaking their contracts. Why? Because they're not honorable, that's why. Is there anything else about it that makes any sense? Did you or did you not agree? Is your word your bond? In that capacity, it doesn't sound like a real good situation. But nonetheless, let's take a look at John Stewart's deal. He's indicted. A year or so later, I'm involved in the case. He's way down the road. We have to fix the case. What are we going to do? We went and pulled a certified copy of the indictment out of the court. You can go get it at the clerk's office. That was a presentment he was given over a year ago and started fighting and arguing and attorneys and this and that, and he's way down the road. Now I know that those 4 or 5 questions that go to the only reason we need the public involved is because the private parties haven't resolved it. Who brought the charge against A. John Stewart? The prosecutor, right? Does he know the prosecutor? No. It's just somebody that filed a complaint on behalf of the people of the state of Arizona. Who's the people of the state of Arizona? All they did was bring him a commercial presentment on somebody that's upset. The people. Where's the people? Where's my accuser, right? That's what people want. Where's my accuser? This isn't right. Well, it's a new game. This game isn't new. Equity law, chancery courts, that's all been around for hundreds and thousands of years. This isn't new, it isn't fraud, it isn't anything. It's the rules to the game. So John gets a certified copy of the indictment. Complaint, information, whatever you want to call it. And we take it and we do a conditional acceptance on that thing with an affidavit in support, an affidavit in negative affirmative form. And what did we do with it, do you think?
Sent it to the prosecutor and to the judge.
Very good. Now, let's get something a little understood, because many of you are going to find yourselves in a court, as we call it in layman terms, a court. You've got the judge and the court, as we call it, okay? Superior court, federal district court, state court, whatever it is. And you've got a prosecutor down here, or a complainant, or whatever, and over here we got you. This prosecutor makes up a complaint and he sends it up here to the court of the judge, right? So I'm going to give it to Juanita. She's the court, clerk court, judge court, the clerk of the court. All this thing up here is filed up. What's the judge in the court going to do with that? They're going to send it right over to you via an arrest warrant and the police, and they're going to indict you, or they just send a summons, or a myriad of ways it gets to you. Bottom line, you're going to know you got somebody giving you an opportunity. What do you usually do with that? Usually go get an attorney or whatever. But if we remember, we got 4 things we can do with that document, don't we? We can accept it, we can conditionally accept it, we can go silent about it, or we can argue about it. When we hire an attorney, we don't go silent, we argue like to hell and back. Well, of course, that's what dishonor. We're a debtor. We're going to lose. Unless there's a couple of debtors out there and the judge will let that get away. But when you usually have the government up against the people, they'll shield the game and let a few go through because they've got to feed the brotherhood. But in reality, They don't have to let anybody through. But then everybody just, all the slaves would revolt because they don't know any better. They think there is no law. They just do what the hell they want, like they kind of think now, because some people went here and there, and with your TV and radio and drugs, you kind of keeps you calmed down a little bit, so you don't get crazy enough to go get armed up and go fight the government and stuff when the government's there to help you. So here we have that. Now let's talk about another guy. We're going to come back to this. So technically, believe it or not, this is the court here, you and your brother. This judge here, he's just going to watch and see what y'all do. And because Jimmy and John can't get along, well, tell me about the situation with Johnny's bike. Well, he let me use the bike, and then Johnny jumps right in. But I didn't. Hush up, Johnny. Let me just hear. I'm the judge. You'll get your chance to talk in a minute. That's all the judge is saying. You two can't work it out anymore, so we're going to talk through me. Of course, well, we never had a fight with the prosecutor to begin with. He already knows what's going to happen. So sometimes they'll run the public side right parallel with the private side. Sometimes the private side's done in advance. Sometimes they do the public side, then the private side. But both sides are going to get done. So, when I get this indictment from the court, and a guy like Tony Christensen, he's doing, if you heard some of the stories about the guy with the Harley Davidson, I have a doctor up in Wisconsin, and he did an acceptance for value on a Harley Davidson bill about $22,000. He went back and forth with the bank, and the bank can't settle it with him. Now, he settled it in the paperwork, but the bank keeps wanting it in the bill, so they file it with some kind of a public entity, and he gets an invitation to come to court. What did Tony do with this invitation that was given to him? He calls me up and says, I got great news. I got an invitation to come to court. I says, what's so great about that? He says,
Somebody's phone going off.
yes, my phone.
Yep.
He says, it's a great opportunity to practice without being doing it on my home or something important. I was 22 grand on a Harley that isn't worth the debt because the market's dropped, etc. But nonetheless, we respond. We only have 4 responses. And since he'd already settled the matter, we chose a conditional acceptance. What is this invitation really saying? What is this offer really saying?
You haven't settled.
Would you like to come on in and let us decide this thing? So what's our conditional acceptance? I'd love to come in. We conditionally accept your offer upon condition that any determination or decision in the matter shall be in accord with the record and pleadings, that's his administrative private side, attached herewith, which is accepted, has not said I'll settle and close the matter, or will be in accord with that. Then we take this and we send this right back. We took this, we sent it over to the opposing bank, and we copied the court with it. Actually, we give the court the originals and we send the copies to the prosecutor. Now this judge saw what we did with their offer, right? Now this judge is going to see what these guys do with the offer we sent back over to our brother via the court. And since we can't get along, we're not settling, he's a mediator, the judge thinks, so it all has to pass through him, that's all. He's just the mom. He's the judge, that's it, to evaluate the contest. Does that make sense to you?
Yeah.
If you can get that in your mind, it's really a critical point to success in the future, because you're almost always going to get remedy on the private side. You can go do your stuff back with the bank about credit cards and car payments and homes and all sorts of stuff. What do they most always do? They agree with you. Do they not?
Mm-hmm.
They almost always do. Yes.
Gordon, what you're saying is you know, you're giving it back to them with the private remedy that you both agreed to, and you're conditionally accepting and say, I conditionally accept that we bring that along with my acceptance, what we've already provided the remedy in the private
Right.
between you and your brother.
The
And
judge
you
says,
always-
hey, I want to hear this matter and make the decisions. I said, that's an offer. I'd love you to, and I conditionally accept as long as you do it in accord with the agreement attached
between
here
the
too.
agreement that you and your brother already worked out.
That's right. I know they're going to come in and keep saying, we didn't agree that, we don't agree with that. That's what he's there to fight about.
But if he fights over that, he doesn't want you. However you come to that agreement is not something he really wants to discuss in public.
Oh, this is where it really gets good. Motive is determined or evaluated objectively. What did I say objectively meant? Objects, things, something outside the mind, right? So the judge knows, he knows what the bank really meant is whatever not what they're coming in and talking about now. He just wants to know, what did you do? Did you agree when they sent the coupon in or the voucher in to pay it? Did they keep it? Contract law, we sent you on Brian Blum, silence or inaction. It's in Restatement Second, Williston on contracts. Every contract book will have something regarding silence or inaction. There are two situations in which silence binds the offeree, whoever made the offer. The bank sent you a bill, said you owe $19,000 on this credit card. You filled out the voucher and did the conditional acceptance, sent it to the CFO. What did they do with it? What's the CFO do with it? Does he keep it or does he send it back to you? Have you ever seen where he sent it back?
No.
So he kept it. If the offerer proffers property or services with the offer, and the offeree, having the reasonable opportunity to return or refuse them, exercises any ownership rights over the property or keeps the benefit of any service, the offer is accepted. So if I sent it to the CFO or to the other party and they kept it, it's accepted, isn't it? And an acceptance means a binding contract is formed.
And with some things, they're also accepting a benefit with that if it's a tender.
Well, if I sent the
payment.
voucher in, isn't that a benefit? It's
Right.
got my signature on it, it's money.
But in some cases, there is no benefit. Like if I send somebody a claim, but there's no.
That's a different deal. We'll talk about
Okay.
silence
Okay.
or inaction. We're talking about wherever somebody sends something to somebody and pays it with a credit card or some other thing, your mortgage or what have you. They've kept that. We're talking about credit cards now, or if there's a Harley payment and the bank sends you a bill and you send the whole voucher back paying off the whole thing. Did the bank keep that worthless piece of paper, as most people would call it? Sure did.
So they're the debtor. And
Well-
they're arguing. You never argue.
Well, that's right, but most importantly, motive is determined objectively. I know that the judge is going to see that the bank kept the voucher. Doesn't care whether it's good, bad, or indifferent. He knows what money is. Money is a broad term that refers to any instrument that can be used in the resolution of debt. We talked about that a little last night. Because all the Patriot guys talk about, well, there's no more gold behind the money. Well, thank goodness. Now I can set off everything. Now I can get away with murder. I like it.
So if I sent this plastic pen in as a payment and they don't refuse it, that's,
If you said by keeping this pen, there's discharge of the debt, and boom, boom, yeah. If you can hold on to that claim, that's right. You bet. He offered a pen in exchange. You know, mortgage companies used to let you make partial payments on your mortgage. And then there came a time when they won't do it anymore. Because they found what happened is some guy would say, send them, a third of the mortgage or half the mortgage payment. Then the guys found out, wow, under contract law, when they cashed that check, they took the bank into the mortgage company and said, look, we renegotiated the contract and made the payment in half. How do we know? Did they cash my check that paid half the payment? Yeah. Well, he said it was just for this. Judge, my understanding was for a new mortgage payment. Let me tell you, you're screwed. You ever get some checks that say by cashing this check, the account's paid in full or whatever? It's not the full amount? That's right. There's a contract. Contracts are dynamic. They move. Is that good or bad? You make a contract and all of a sudden the damn thing's moving. Is that right or wrong? We get air in here? You think we'll need it? We'll make it cooler in here? Contracts are dynamic, or it means they can move. They move or they can move. Is that good or bad? Is that, I don't know. Is that good or bad?
Good if we understand that.
Well, it's either good or bad. I would agree with you. Technically, it's good if you understand it, bad if you don't, because you think you make a deal and then all of a sudden it gets moved.
It's good if we take responsibility for our actions.
So if you're undermanned, where you don't have to be an undermanned means you don't have to take responsibility to a big degree, right? You can go to California and it's legal to get marijuana at the co-op, and if you go to Vegas, it's legal to go get laid and pay for it. Prostitution, and over here this is legal and that's legal. Does it mean it's right? Under man's law, it means it's right. Because what did we say right was? In accordance with law, justice, or morality. What did I say law is? Every time you see the word law, I told you to replace it with what word? Contract. Contract. So, when I see the definition, right, in accordance with law, justice, or morality, then it's real easy to say in accordance with contract, justice, or morality. So in that context, is what this government doing right? You bet it is. It's a contract. So you're now in accordance with that contract. That is right. Is it morally right? Well, that's a different question, isn't it? But right it is, based on, if we agree that that Webster's definition is in accordance with law, justice, or morality, if we agree that that can be the definition, then it is right. Is it right that they can come into your home or kick your door down? Well, I don't know. Is it your home? Whose home is it? Is it your home, Juanita? Or is it Juanita's home? I think it's probably Juanita's home. Which Juanita am I talking about? The artificial person or the natural person? The artificial person, huh?
Mm-hmm.
And therefore we have divided title. Legal title's in the state, and equitable title, or 9/10 of it's in the possession of the natural person, Juanita, who's run around sailing the good vessel, Juanita, on the Sea of Commerce. Some of you are starting to deal with these mortgages, and you notice deed of trust, and the deed of trust ones where the grantor or settler, which is us, who signed that promissory note, appointed somebody else as trustee and beneficiary, correct? Do you understand that? If you get a deed of trust out, you'll notice that there's a grantor, a trustee, and a beneficiary of trust. And the reason that you can do some, what you need to get, I sent Juanita a thing on trust that explained trust real easily.
Everybody got it.
Good. If you read a little bit and you understand trust, one of the features of a trust is divided title. Some of you are familiar enough with a trust to know you could set up a trust for your child. So you might put a bunch of money into Hall Family Trust, and I might make Juanita the trustee to execute the trust indenture or the contract. She accepts being trustee. She's bound by the trust indenture or the trust contract. Does that make sense? Now, if I made it a statutory trust, one of 85 statutory trusts in America, then the government gets control of that. Or if I make it a complex trust established in contract, irrevocable on the private side, they can't touch it. They can't interfere with it. Whole different deal. Because you're the sovereign. Sovereign means what? Authority. Sovereign isn't a thing. It's kind of like an office. You're the authority. Every time I see the word sovereign, I just replace it with authority. Every time I see the word law, I replace it with contract. Every time I see the word as, I replace it with in the capacity of. And every time I see to, let's see, what do I do with to? Resulting in. Those are about the four major words I change up words with. Every time I see law, I think contract. Every time I see as, I put in the capacity of. And every time I see to, I say resulting in. So when I read a definition in here, like assert, is to state. So I think in my mind, is resulting in state. Ah, that makes sense to me. I like the way that reads to me. Is to state positively with great counsel with no objective proof. Declare is to assert. Is resulting in assert. And then it goes on to give some more definition to it. So if you'll consider replacing some of these, and then of course then this is a big one. You broke the law, you've been told. You violated the law. You violated the contract. Which contract? Let me give you an example. A friend of mine got out of prison, wouldn't sign any supervised release papers, and he told his dad, if they get a hold of you, let me know. A summons came from the court in Chicago to appear in court because probation says he owed probation. So he goes to court and the judge says, Mr. Seehausen, why aren't you doing supervised release? And he says, where's the contract that obligates me to do it? That's what he hung on for like over 7 hearings. There was lots of interesting things about it, but that was essentially the crux of the deal. Where's the contract that obligates me? He's not understanding what contract really means, but he's saying that. He's asking for the record or memorial of the contract, actually. You remember that this signed document that I have here is not really the contract. It's called a contract and referred to as a contract, but strictly speaking, it's not the contract, is it? Does that make sense, or you lost on that one, Lou?
The contract was formed by the acceptance made it by.
A good example is this divorce deal I did up in San Francisco. The gal moved in 11 years before that, got legally married 3.5 years ago. So lived with a guy something like, call it 7 years, 6.5 years before they recorded it or memorialized it legally via, a license or something. But when she moved in, he threw all of his furniture out, she put hers in, and they went on living happily ever after. Are they married? In her mind, she was. His mind, probably so, or not. He just has himself somebody to sleep with and a girl in his life and that kind of thing, and she's got security and somebody to sleep with in her life. But technically, they're married. Because what does married mean? To join together. Obviously, they're joined together. Jeez. Form a union. That's right. Doesn't matter if they change their names to be the same name or not. They actually did when they legalized the marriage, she not realizing she could have changed it back then. Just inform on the public side, my new name is Gepter. It's not, or my new name is Smith, not Hall now. Don't women do it every day? Movie stars change their names too. All the time. So, to win that case was nothing more than, and the other attorney saying, well, under California law, she's not entitled to the house, and not entitled this, and not entitled that, and has to pay him money, and all this. Under California law, that's right. But I'm not talking California law, I'm talking private law. Well, where's the proof? How's she going to prove that she was married? Well, we talked about proving anything, right? That's a real critical deal about figuring proof, onus probandi. I don't want to keep going down all these little mundane rules and principles unless you'd like to hear them. If you do, I don't mind doing it. But if you're all well versed in this can be rather boring for you, and I don't want to bore you. We can move on to how to obtain remedy, or we can underpin with a few principles. And if we come back to these principles always, you can understand what's happening to you always. For example, Juanita the other day calls me up and says, we got a problem. Jim Short, he went into court and tried that stuff and got blew up. Okay, well, let's figure out what happened. He went in, and we got Dan Cobalt on the phone. He went in, and he said, I'm here today as Tom Short, intervener for the purpose of helping the parties settle all claims or charges outstanding. And after 3 of those repeats, the judge essentially blew him up. And Juanita was pretty concerned about it, which is a good thing, because all of a sudden everything she'd been learning that I've been teaching went out the window. That doesn't work. This isn't maybe Gordon. He said that and got blew up. That's pretty black and white. 1 and 1 is 2, and 2 and 2 is 4, and he got blew out. I said, well, let's figure out what happened. So we go back to, there's always an answer. She wasn't out of line with that comment. It was a good one. I remember myself asking those kinds of questions to people I was learning from. So his ex-wife sends up to the court, I don't like the old contract I got. I like some more money. That's what she's saying. And I want you to go tell that deadbeat yak that won't just give me more because I want it, that I want more. So the judge or the court sends it over to Tom Short. Hey, dude, she wants some more money. And what did he do with that offer to have his contract redetermined or reevaluated by the judge? What did he do with it, Juanita?
Nothing.
He went through door 3. He went silent. Or door 1, he accepted it. Okay. I agree. Let you just make the decision on it. So he comes into court and he wants to stand on a claim. What claim? He got something and he dishonored. He's a debtor. He's got nothing coming. End of game. I don't have to go any further. But had he simply taken that summons to come into court and said, I conditionally accept your offer upon condition that any determination or ruling in the matter shall be in accord with the record of the parties. Because remember, that's the record of their agreement. Attached herewith, so I'm going to put it on the summons, which is accepted, that has settled this matter about how much she's to get. And I'm going to send that back over to the ex with the original certificate of service that I sent it to these people, my brother, and a caption set with a court or a letter, and the court's going to say, okay, you conditionally accepted me hearing it based on the contract attached here too, and since I gave it to the ex and her attorney, what are they going to do with my offer that, hey, we can go in there as long as it's in accord with the previous contract? That's what it's going to be ruled on. What do you think his ex-wife's attorney who filed the suit would have done with that offer? Nothing, because the rules of court require him to do nothing with it. That's why. He can't do anything with it. That's the law. Those attorneys are bound by a very strict set of rules. You will not counteroffer his. I don't care if they know this stuff or not. They ain't allowed to use it. God, I love this government. They make sure you get remedy. They're not stupid. You think they don't understand some of this stuff? There's some attorneys that do, but they can't use it. They're precluded from it.
Now that attorney, he could probably lie to her and say something just to extract more money out of her.
Oh, hell no. This guy ain't got nothing coming. We're going to go and kick his ass. You're actually going to pay, honey. Give me a couple more thousand. We'll get in there and get him, Tiger.
Yeah.
Man, this has turned out just a little tougher than I thought. Better give me another fee, because he got all this weird, stupid stuff. He's crazy. I got to have this check. I got to have it. Just give me another check. Now, this judge is going to see if Jim knows his business when he comes in. Going to call the case, and the attorney's going to stand up. Tom from Dewey, Cheatham, and Howe, representing Mrs. Smith, who needs some more money, Judge. And he's going to stand up out in the gallery and say, I'm here today as Tom Short, intervener for the purpose of helping the party settle all claims or charges outstanding. Judge is going to try and get him in the bar. Well, just come on in here. Or what'd you say? I'm here. Just come on in. It did to my friend of mine. He walked into the bar, introduced himself as, I'm here today as Scott C. Housen. We weren't using intervener at that time. Secured party creditor, private trustee for the purpose of helping the party settle all claims or charges outstanding. If it please the court, may enter the bar under said terms and conditions. The judge goes, what? He goes, I'm here. He goes, just come on in. My buddy just walked in. Then the judge said, now get over there and sit next to your attorney. And he actually went over and sat down to an attorney who talked to him about 3 times out before the court started. They saw him coming a long time before. And because that attorney got him familiar with him, just talking to him, he went over and sat next to this attorney. His attorney the judge ordered. When he started reading new charges about filing false documents, he goes, excuse me, may I say something? He says, no, shut up. Because he knew that this guy would kowtow properly, that kind of treatment. I don't know how they know these things. They sense a little blood in the water, they're going to rip your liver out, ladies and gentlemen. It's their job. When the judge says, what? I'm here. Just come on in. I'll be happy to come in as long as it's as, or repeat, I'm here today as Gordon Hall, intervener. Okay to come in on that basis? Help you all settle this claims or charges outstanding? You don't have to be like over formalized with it. Great. Then it's okay if I come in as intervener merely for the purpose of helping the party settle all claims or charges outstanding. Agreed? What's the judge going to say? He's a little stuck. He knows you know what you're talking about, especially if you're kind of smooth with it. You don't go, I conditionally accept condition, and go through this rote stuff. Ease up a little. At first you won't, but you'll get to it. And it's straight downhill once he gets jurisdiction. Just stepping in the court didn't kill him. Taking the order to sit down was the second witness, the second shot. He lost it after that. And they arrested him. Then the marshals stood around him real close. And he's gone. He's still in this over a year later.
What do you mean second witness? That was interesting what you just said.
Well, one little mistake isn't often going to get you trashed. But it can. Clerk says, is your true name Gordon Hall? Yes. That's all they need to hear. Or judge says, state your true name for the record. And you say Gordon Hall. I'm here to, I don't care what he says, I'm here today as Gordon Hall, intervener.
So
not Gordon Hall defendant, Gordon Hall, intervener.
The judge was maybe giving him a second chance by giving him an order. He proved the second time that he wanted to, whatever, take orders.
That's where what's called latches comes in. Inexcusable delay in enforcing a claim or estoppel. The barring of a person in a legal proceeding from making allegations or denials which are contrary to either a previous act or statement by that party or a previous adjudication. You're expected to know your business. You get a lot away with a lot of it on the private side, back and forth with paperwork and stuff, but when you actually get into a public court, you don't get to just refix everything. It goes nuclear in a hurry. And this is why you have to know who you are, so you can get remedy. Yes?
So with this fellow being in jail now, that we were just talking about, have you got any way to turn that around? Get him out?
Yeah, I believe he can get out, but I'm not overly interested in trying to get him out. He's a friend of mine, but he's a putz. He's a con man, steals from everybody, and, you know, in hindsight, you know, I don't have any use. He's where he needs to be. So I'm not worried about getting him out. Not worried about assisting him or any other thing. I like him, but I don't like his behavior. Therefore, you know, he's got what he needs. He's my original mentor in this stuff. When I lost contact with him, I was still in. He flew me off while I was in and needed his help, etc. Took some last money of mine, which didn't really mind because I figured it was well worth the education. And then when I was trying to enlist him to help me with some stuff on the outside, he was just impossible. Had to pay him for his time and all sorts of things. He owed me and did this and that. Had conned somebody I'd introduced him to out of 10 grand, and et cetera, et cetera. And the long and the short was, I gave him advice to do, but he was turned into a party animal, this and that. And his habits got the better of him. He was an alcoholic a little bit, drugs, that kind of thing. And, you know, I quit, Karen, you know, and got in, found out he got to my buddy for 10 grand, you know, that I'd introduced him to, and just realized he's just straight con man after that. I just wasn't overly concerned with it because he needed to be there. He just can't control himself. So, anyway. So when you're really, so whether it's Tom or Scott or anybody, it's all offer and acceptance. And if you can get in your mind what the game is, you get a summons from a court to come in. On what basis do you want to come in? And why would you keep such a summons? You only have 4 doors with any written or verbal presentment. And you know what the last 2 are going to do for you, nothing. And quoting you court cases like U.S. versus Prudent, silence can only be equated with fraud where there is a legal or moral duty to respond, or where an inquiry left unanswered would be intentionally misleading. I got the right to take the Fifth. I can go silent. Yes, of course you can. And you can burn in hell for it. That's the part they left out. Because actually the Fifth Amendment wasn't put there for you. It was put there for government. So they could go silent without incurring liability. You got some constitutional rights? Anybody here have constitutional rights? I have constitutional protections and guarantees, but I don't have any rights from that document. What's really cool about that document, if you read it, you know, in the back of these law dictionaries, you'll find the Constitution. The Second Amendment says something along the lines, the right of the people to keep and bear arms shall not be infringed. How can that be possibly construed with any reasonably intelligent or prudent person? That means you have a right to carry a gun. That's an implied order to somebody that you're not going to infringe on the right of people to keep and bear arms. That's right. The states made that document for their benefit. They formed a federal government for their benefit and safety. And when the states made that document, or that constitution, in order to form a more perfect union, to establish justice, to ensure domestic tranquility, to provide for the common defense, etc., it was an order to their new entity called the federal government that you're not going to infringe on the right of the people to keep and bear arms. That was a tacit, that's an expressed acquiescence that the right of the people to have arms is there. The Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. So what's the federal government doing? Talking to everybody in America. Going in and raiding homes and this and that. Man, talking to you. What part of this don't you get? You're not Tom, you're not Pat, you're not Gordon. They're not talking to you. But you don't know any better because you don't know who you are.